Okay. Hi, everyone. I would like to begin by acknowledging that I'm speaking today from the unceded land of the Wurundjeri people of the Kulin Nation, and to pay my respects to their elders and families past and present. I would like to acknowledge too the ongoing existence of their laws. There is no pride in genocide. So thank you to everyone who has joined us today for this virtual discussion panel. My name is Adil Hassan Khan. I'm a senior research fellow at the Melbourne Law School. It's a real privilege and a source of enormous pleasure to chair this discussion panel on the topic of Palestine, race, and international law, which is being hosted by and organized with the incredible support of the Third World Approaches to International Law Review, or TWAILR, especially due to the tireless efforts and support of Dr. John Reynolds. So on this panel, today we are joined by Dr. Nahid Samour, who is a research associated at the Radboud University, Nijmegen, in the Race, Religion, Constellation Research Project. Dr. Samour is one of the most acute commentators on the racialized and racializing histories of the recognition of genocide by the German state, and how that has variously entailed the construction of Palestinians as an undesired community, amongst various other sort of accomplishments in the field. We are also going to be joined by Dr. Shahad Hamouri from the UK, who is just on her way from the airport after a long journey. Dr. Hamouri is a lecturer in law at the Kent Law School, University of Kent in the UK. Amongst other things, her scholarship is concretely attentive to and draws attention to the political economy of Israeli settler colonialism in Palestine. Next, we are joined from New York City by Professor Vasuki Nasaya. Vasuki is a professor of human rights and international law at the Gallatin School, New York University. She's a founding member of TWAILR and has written widely, including on international law, human rights, and race, with a forthcoming monograph titled Reading the Ruins, Colonialism, Slavery, and International Law, and recently has given a series of fantastic and really unmissable lectures on genocide. Finally, there's Dr. Christopher Gievers, who is joining us from Durban, South Africa, where he's a lecturer in law at the University of KwaZulu-Natal. His committed scholarship on the topic of race, colonialism, and international law has been at the forefront of a productive engagement between critical race scholarship and third world approaches to international law. So in terms of the format for this 75-minute discussion panel, we will begin with each of us panelists speaking to the theme of this panel, taking one of the three proceedings before the ICJ that we referred in our description as their point of focus and reflection. After that, I will request, I'll sort of pose a few broad questions organized around our discussion themes to our panel, which will be followed by a discussion with and amongst the panelists, and we should have at least 15 minutes for audience questions. So please use the chat function to share with me any questions that you might have. This panel is being recorded. It will be shared on the TWAILR website. And thank you so much. Also, getting us started off, I want to ask Dr. Samour, can you please share with us some reflections on our theme, focusing on the ongoing proceedings at the ICJ in the Nicaragua versus Germany case? And just to sort of set it up for folks, it's a case in which Nicaragua has argued that Germany has breached its international obligations under the Genocide Convention by facilitating and failing to protect Israel's ongoing genocide in Gaza. Dr. Samour.
Thank you so much for inviting me and for organizing this fantastic panel. I'm really honored and delighted to be part of this. So as you just said, Nicaragua instituted proceedings against Germany for facilitating the commission of genocide and failing in its obligation to do everything possible to prevent the commission of genocide. And Nicaragua is turning to the ICJ because Germany, as a third party to the South Africa versus Israel case, is said to have failed to fulfill Germany's obligations under the Genocide Convention. Now, obviously, there are also questions regarding jurisdiction and admissibility, which I will not go into right now. Instead, I would like to focus on two main questions regarding genocide, underlining the very importance of the Nicaragua versus Germany case. There are two things here that become acutely relevant. One, the state's duty to prevent genocide under international law, and two, the matter of complicity in genocide. So international legal scholars will look to this case, hoping that the International Court of Justice will use this case to outline what is the state's duty to prevent and what is the question of complicity exactly. Beyond that, people will look, of course, to the case to see and to understand how it is that it's not only Israel's actions, Israeli military activities in Gaza, possibly amounting to genocide that is being tried, but how is it also that other states invested in Israel are also being tried before the International Court of Justice. So as I said, the Genocide Convention comprises both the duty to prevent as well as the duty to punish genocide. And both become very relevant in connection with Germany's delivery of weapons to Israel and Germany's defunding of humanitarian aid to Palestinians in Gaza via UNRWA. Now, under international law, states have a duty to prevent acts of genocide. We will still need to see how the International Court of Justice will define this within the Nicaragua versus Germany case. But what we do as lawyers is to go and look at previous precedents, cases that were already rendered by the International Court of Justice to make us understand what it means to have that duty to prevent a genocide. Now, it's not necessary for a definitive determination that genocide is taking place. That we know through the International Courts of Justice decision in Bosnia versus Serbia, which means that we do not need to wait for the International Court of Justice to decide on the merits of the case. The International Court of Justice in Bosnia versus Serbia said that a state's obligation to prevent and the corresponding duty to act arises at the instant that the state learns of or should normally have learned of the existence of a serious risk that genocide will be committed. So we recall that the International Court of Justice by now has twice issued provisional measures regarding the plausibility of a genocide being committed by Israel in Gaza, Palestine. But we also know that by mid-November, UN special experts started calling on the international community to prevent genocide against the Palestinian people. And actually a month earlier, mid-October, 800 scholars and practitioners of international law, many colleagues engaged in third world approaches to international law, already signed a public statement warning of the possibility of genocide being perpetrated by Israeli forces. So you could say by mid-October, maybe latest mid-November, the German state and other states were basically had enough information to look into the matter. So based on this, such a threshold has been reached in Gaza, triggering states' duty under international law to take measures to prevent acts of genocide. States' legal obligation to prevent genocide is not a passive obligation, but rather, again, according to ICJ in Bosnia versus Serbia, implies that each state party must assess whether genocide or serious risk of genocide exists. Now, the Genocide Convention imposes a minimum legal obligation on states to take reasonable action to contribute towards preventing a genocide. A duty that extends extraterritorially, i.e. even beyond its borders. And it's an obligation imposed on any state party which in a given situation has in its power to contribute to restraining in any degree the commission of genocide. And any state with capacity to make any such contribution must employ all means reasonably available to them. This is important also because the International Court of Justice in the Bosnia versus Serbia case held that states with strong political links to the state concerned have a greater duty to use their influence in this regard, as the duty to prevent varies from state to state depending on its, quote, capacity to influence effectively the action of persons likely to commit or already committing genocide. The capacity itself depends on other things, depends among other things on the geographical distance of the states concerned, as well as the strength of the political links, as well as all other links and links of all other kinds between the authorities of that state and the main actors in the event. This means that obviously for states that are either in geographical proximity or, and actually I even consider Germany to be in geographical proximity to Israel because as we know, people came from neighboring Syria, people came walking to Germany just a few years ago, but particularly because there's like the very strong kind of diplomatic link that we know with that the duty to prevent actually rises. So with this third state responsibility may be incurred if a state manifestly fails to take all measures that are within its power to prevent acts of genocide. These normative explanations, by the way, were not refuted by Germany before the ICJ at all, as I will explain in a minute. It was more on a factual grounds that Germany prepared its statement before the ICJ. The second question here is the question of complicity, i.e. the role of third parties in genocide, which is laid down in Article 3 of the UN Genocide Convention. So the genocide definition itself in Article 2, the question of complicity in Article 3. And here the difficulty lies in the definition what complicity might mean for a state vis-a-vis what complicity might mean for an individual. This is important because we have both adjudication coming from the International Court of Justice, especially the ICJ 2007 Bosnia versus Serbia case, as well as adjudication coming from the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda concerning individuals. So here we're actually all waiting as legal scholars to see in what way complicity will be further defined by the ICJ. Now, in the 2007 Bosnia versus Serbia case, the court upheld the notion that the Genocide Convention actually provides states as well as individual responsibility for genocide, the so-called duality of responsibility. And in the International Criminal Tribunal of the former Yugoslavia, it considered the relationship between complicity in genocide similar to aiding and abetting genocide within the terms of its statute. And essentially settled the law on aiding and abetting genocide while still leaving some issues partially unresolved. So one of the key questions will be whether complicity in genocide equals aiding and abetting genocide, and whether these are two different concepts, and what the interrelationship is between the concepts or the distinction. And most importantly, maybe the question of the degree of intention for committing complicity in the crime of genocide, the foreseeability or the certainty. That's what legal scholars are also waiting for the International Court of Justice to become much clearer about. Now, I want to say a few words about Germany's statement before the International Court of Justice, particularly regarding the question of delivery of weapons and the defunding of humanitarian aid to Palestinians in Gaza. As for weapons, first of all, what actually the German government itself issued was that in 2023, after October 7th, 308 individual licenses for exports of military equipment to Israel were authorized, with a total value of approximately 326 million euros, according to the German government. This marks a tenfold increase from 2022, where the total value of approved licenses amounted to only 32 million euros. So the largest volume of these licenses in terms of value was authorized in the second half of 2023. And according to German media Tagesschau, 180 individual export permits were approved in the 26 days between October 7th and November 2nd alone. Now, I want to mention a particular problem that lawyers in Germany and possibly other countries as well are very much aware of, which is the distinction made by Germany, which is a distinction irrelevant to international law, but the very distinction between war weapons and other military equipment. Now, this is a game, if you want, that governments play and with which they can distort some of the facts in presenting how much, basically how much kind of deadly instruments were exported. Now, Germany's presentation did not necessarily contradict Nicaragua's presentation, but it can be read as an attempt to play with the facts or distort the facts. The German side spent quite some time stressing the very distinction between war weapons and other military equipment, which is the very kind of distinction made by German domestic law between the War Weapons Control Act and the Foreign Trade Act. It's, again, a distinction that is made according to domestic German law, but a distinction that is not relevant. It doesn't actually exist in international regulations such as the Arms Trade Treaty that is actually of relevance. So arguably, Germany has largely neglected their duties arising out of the Arms Trade Treaty. And this distinction, as I said, has not only been criticized by scholars and lawyers in the field, creating the very double standards by making it more lax for certain articles to be exported. This is why, for instance, Germany kept on reiterating the helmets, for instance, that were sent. But again, as I said, this distinction has no significance in international law. What I think is important to mention here is that Germany mentioned that the war weapons themselves, which is the 500,000 rounds of ammunition, were supposedly meant to be for training purposes. And they insisted that Nicaragua failed to mention that, even though the information was nowhere to be found in previous inquiries to the German state made by opposition politicians. So the amount of so-called training material is interesting, but because it is known from Israeli news sources that there wasn't any training session going on since October. So the question here is, why was there the urgency to get all the training ammunition to Israel after October? In fact, Haaretz reported in Hebrew that testimonies by soldiers who said that they have used ammunition and propellants marked for training only against targets in Gaza. On March 20, 2024, Haaretz reports how in one of the units, the lack of ammunition got to the point where they received a shipment of shells that had apparently been labeled for training only. After going up the chain of command and inquiry, they finally fired them in Gaza. So that also means that it would not be the first time that, in fact, it means that it's not the first time that military material is being field tested on Palestinians, something Israeli military companies pride themselves of when they do the military arms sales. And again, it's relevant also because 70% of those killed by Israeli weapons were women and children. That's relevant because in the Gambia versus Myanmar case, also pending before the International Court of Justice, it was actually Germany together with Canada, the UK, Netherlands, and Denmark, making the very case for widening the understanding of genocide precisely when it hits children and women. So what we have seen before the International Court was not necessarily kind of a legal normative defense, but very much downplaying the support for Israeli military action, which in a way actually contradicts the very announcements we've heard inside of Germany, namely Germany not only paying lip service to Israel, but also being there materially when Israel needs to allegedly defend itself. The other question, and I'm going to conclude with this, is that Germany priding itself before the International Court of Justice to be one of the main kind of financial supporters of Palestinians, or in the UNRWA in particular, which is probably true when you look at the amount of money paid to UNRWA vis-a-vis Palestinians in Syria and Lebanon, in Jordan and the West Bank. But basically, Germany, even before the International Court of Justice, made no mention that, in fact, they stopped all the funding to UNRWA in Gaza, which is possibly one of the reasons why we're seeing increasing amounts of famine and starvation, also as parts of the construction of genocide in Palestine. So maybe I just want to round up with a quote actually by Stephen Salater, who said that genocide is more than a military event. It also requires compliant politicians, institutional complicity, collective denial, coordinated misinformation, racial hysteria, systematic repression, dishonest reporters, opportunistic pundits, dissembling intellectuals, and corporate profiteers, and each now exists in abundance. And I think this is one of the cases that really make us think about how both, the legal and the factual, the media, and I'm sure we're going to also talk about it, the role of universities and intellectual scholars will be part of trying to explain how we came to this point of discussing genocide in the first place. Thank you.
Thank you so much, Naya. That really was most instructive, and how you unpacked the arguments before the court. Because I mean, one of the things about Nicaragua versus Germany has been there's not much commentary that's come out, especially in even in the press, which is perhaps not the case with the other two cases. So thank you for setting us up. Next, I'll call on Shahad in recording. So Haris, if you can set up the share screen. So Shahad sort of is on her way, so will be joining us soon. So, but this is a recording that she has sent through. I'll just say, so this will be sort of, these are reflections on the theme through the South Africa versus Israel case, in which, just to set it up, the state of South Africa has argued that Israel is in breach of their obligations under the Genocide Convention by committing genocide in Gaza and for failure to prevent genocide. And in the court, of course, unanimously ordered 6 provisional measures back in January this year, in which the court found it plausible that Israel's act could amount to genocide. At the end of March, after South Africa returned to the court with a request to issue new provisional measures on the basis of widespread starvation, the court further unanimously ordered Israel to ensure unimpeded access to humanitarian assistance into Gaza, observing that famine was now setting in. This time around, 7 judges, including the Australian judge Hilary Charlesworth, also called for a ceasefire. So, Haris, please. I think you can't hear the sound, Haris.
It's because I was held up at the border. I apologize for this unforeseen change of circumstances that was necessitated by bureaucratic arbitrary decisions that link back to the precarity of holding a Global South passport. And I'd like to thank Adil and my colleagues at the panel for organizing the discussion, and once again convey my apologies. And thank you for agreeing for this flexible arrangement. So I was asked to speak briefly of the case of South Africa versus Israel in relation to the Genocide Convention. We cannot speak of the word genocide quite lightly in face of what we are seeing. Of course, genocide is a typical feature of settler colonization, and we have had too many historical lessons learned in order not to see this. The main problem stems from the fact that international law has not integrated the perceptions and experiences of states of the global south into its mainstream body. And with that, we had a problem where there was a settler colonial entity, a siege that has lasted for over 17 years, and a densely populated area with over 50% children and 70% refugees, bombarded heavily, and a debate in international law about whether or not this constitutes a genocide is still prevalent even 6 months into the onslaught, despite the clear warnings 1 week into the onslaught, and despite the clearly declared intention of Israel. So the Genocide Convention has extraordinary provisions that allow such proceedings, and the International Court of Justice statute also has extraordinary provisions in cases of irreparable damage. The gravity of the violation of which we speak facilitated this case, facilitated this case on the procedural aspects. When South Africa put forward the claim in December, and luckily it was South Africa, who has a state that has a history with alien domination and subjugation, and at least its lawyers are capable of capturing the systematicity and composite nature of the illegalities at hand. Of course, we were limited to the Genocide Convention, which is a shame in of itself, because this convention was made with a specific perception of reality in its mind, and that is specific to instances, rather than encapsulating the wider possible narratives that we could see in relation to the Genocide Convention. Yet the South African team did a wonderful job in historical proceedings that spoke very heavily to the ideal of justice. South Africa, in the oral and written, the oral proceedings and the written submissions, clearly showed and demonstrated Israel's intention to commit genocide, as well as extrapolating this intention from Israel's actions. At this stage, we only need to ascertain that there's a risk of genocide rather than a genocide that is happening. Meanwhile, Israel responded through tackling some jurisdictional aspects, as well as, of course, putting forth the very infamous argument of self-defense that by now we've all repeatedly listened to arguments against that, specifically with reference to the 2004 decision by the International Court of Justice that says that you can't use the argument of self-defense against an area that you yourself occupy. Furthermore, Israel sought to decontextualize the discussion at hand, counteracting what South Africa took as a strategy in its argumentation, and that is reminding everyone at all moments that this act is happening in a context of larger violations of international law, which extend to violations of Hughes Cogan's norms of self-determination, the prohibition against aggression, the prohibition against apartheid, among many others. So, and last but not least, Israel was putting forth arguments that this is a discussion for international humanitarian law, not a discussion for the Genocide Convention. And as recently demonstrated by Francesca Albanese, the UN Rapporteur on Occupied Palestinian Territories, Israel systematically weaponizes international humanitarian law and specific interpretations of it in order to facilitate or seek to legitimize its own grave illegalities. So these are argumentative techniques that are systematically used by Israel. So, in short, the court found that the risk of genocide does indeed exist, and it issued provisional measures that were aligned with the requests of South Africa, except for one, and that is the call for a ceasefire. Instead, the court opted to say that that Israel needs to stop any acts that might be deemed genocidal. Of course, when we look at that outcome, that outcome could be described as not only indeterminate, but also absurd to a given point. If you are asking a perpetrator to identify what constitutes a genocidal act, even though genocide is a composite illegality that spans across a very wide variety of acts, and it's quite spread across, spread spatially and temporally, and difficult to identify in that way. What we can imagine is that behind the scenes, the court was partaking in what we can call only a balancing exercise between the requests of states of the global south, as well as the demands of justice and the political status quo. What we can see very clearly is that Israel benefits from a deeply rooted status of exceptionality in the international legal system, as well as a normalization of the grave illegalities that it commits, being a contemporary settler colonial state, and that's usually what makes the case of Palestine quite unique, in the sense that it was colonized the moment colonization ended, and Israel has become used to that state of exceptionalism that is deeply aligned with the geopolitical status of the world. So the court was balancing between these two different, very realistic demands, and decided to go with indeterminate language. Of course, it was very clear that Israel would not comply with that. In addition, of course, it asked for a number of provisional measures, other provisional measures, including access to humanitarian aid, as well as safeguarding evidence. 1 month later, Israel was supposed to submit a report. We, I believe, still don't have access to that report. South Africa required for further provisional measures. The court agreed for further provisional measures, this time using language that is a little bit more assertive, however, still not calling for a ceasefire. However, it's notable that 7 of the judges came with separate opinions that asked for and requested a ceasefire. From the perspective of Palestine, of Palestinian people, this was not a time for indeterminate language. And the fact that the international legal system still had a space for entertaining indeterminacy at such a point where we see such direct death and misery live streamed in front of us is an indication of larger problems that are deeply embedded in the international legal system. And here Palestine is working as a pinpoint of critique, again, to help us reflect over the systematic and structural biases embedded in the system as a whole. I look forward to further discussion, and thank you very much.
Thank you so much for these reflections, Shahad. When I was in the audience now, this really sets us up well, and yeah, just sort of the reflections on the theme were really, I think, instructive, and I think sort of we'll work through a lot of these points through the course of the rest of the discussion panel. So, Christopher, could I now request to share with us your reflections on the theme, with sort of focusing on the advisory opinion, which, again, just to set it up for everyone, relates to the request by the UN General Assembly for an advisory opinion from the ICJ on the legality of Israel's prolonged occupation of Palestine, and for which more than 50 states appeared before the court to express their views on the legality of the occupation, and with 24 states and 3 international organizations making the further claim that Israel's policies and practices amounted to a breach of the prohibition against apartheid under international law and amounted to prohibited acts of racial discrimination.
Thanks, Otto, and it's wonderful to be here with you and with so many friends on the panel and in the audience. So what I thought I might do with my time is try to reflect specifically on the topic of race and international law through the lens of that advisory opinion. And in particular, what I wanted to focus on was the section of Palestine's submissions that were concerned self-determination. And why that's interesting to me is because those submissions began and ended with invocations of Hirsch-Lauterpacht. And so aside from positioning a white man as the first and last word on self-determination, I want to explore three, what I want to call fateful omissions of that invocation of Laterpacht in those submissions, and what they reveal about the risks of international law in this present moment, its present and most recent moment of redemption. And so the first omission that emerges from the invocation of Laterpacht is that when setting out the freedom under international law, what it meant in 1945, namely the right to self-government, Laterpacht explicitly excluded Black South Africans, amongst others, from the terms of that freedom. Right? The second omission was the reason for that exclusion, which was not, as it was for others, to allow for the progressive, in Laterpacht's terms, future approximation of that freedom in time, but rather, according to Laterpacht, the situation in South Africa was sui generis because of what granting that freedom to Black South Africans would mean for white South Africans, namely, and I quote, a consummation which would signify the end of a Western civilization, end quote. So according to Laterpacht, Black self-determination in South Africa was, quote, an impossibility. It was, and again, as I quote, not a question of dignity, but a question of existence, end quote. The third and perhaps the most surprising omission was the authority that Laterpacht quoted for this permanent denial of freedom in the name of Western civilization and whiteness, none other than Jan Smuts. And the fourth omission we might add here was that Laterpacht, for reasons known to him but not hard to guess, actually doesn't cite Smuts by name. So he rather quotes, quote, the Prime Minister of South Africa. So these fateful omissions in the invocation of Laterpacht bring to the fore two risks we face in thinking about Palestine, race, and international law in this present moment. A moment of international law's redemption, when it's no longer obvious who is starry-eyed and who is clear-eyed about international law and its potentials. So the first risk is that we separate, as Laterpacht did and the submissions did, race from self-determination. And in fact, not just from self-determination, but from the denial of self-determination, particularly when Western civilization is at stake. The second is that we separate apartheid from colonialism. And here I can point to the work of Noah Ericott and John Reynolds and others, and also apartheid from genocide for that matter, and I'm sure we'll hear about that in a moment. So in this moment, the more productive beginning and end of self-determination, its racialization, its denial, and eventually its contingent recognition is not Laterpacht, it's Haiti. Related to this, the omission of race from self-determination and from colonial occupation, for that matter, in the submissions, meant that race did most of its work in Palestine's discussion of apartheid and as racial discrimination, not, as critical race theorists would understand it, as ongoing white supremacy and colonial domination, not as a structure of past and present, not as a question of global white supremacy as opposed to just being limited to Zionism and Palestine. So the second risk of the evacuation of race and the invocation of Laterpacht, or its silencing, I should say, is that, to paraphrase Chinua Achebe, that we forget the difference between those who have, quote, just come in from the rain and those who have been indoors the whole time. And in particular, we need to remember at this moment the traditions of resistance and thought that have wrestled with questions of race, colonialism, apartheid, and genocide, and the lessons they teach us and that we fail to learn time and again about international law. So to name just one, W.B. Du Bois, for example, read the exact same quote from Smuts that Laterpacht did and sought for what it represented in 1925, writing, it meant the impossibility of Black self-determination in a white supremacist order. For Du Bois, Smuts, and Laterpacht's claim that for white South Africa, the non-recognition of Black self-determination was not a question of dignity, but a question of existence, not only set the darker race beyond the pale of democracy, but beyond the pale of modern humanity. It was a claim that was not both political and ontological. Moreover, for Du Bois, in doing so, Smuts simply, and I quote, expressed bluntly, and not without finesse, what a powerful host of white folk believe but not plainly say in Melbourne, New Orleans, San Francisco, Hong Kong, Berlin, and London, end quote. So as we consider the ghost of Smuts in the Palestinian submissions, we need to consider which traditions and which archives enable us to think race alongside apartheid, colonialism, self-determination, and genocide, and to think Palestine alongside Haiti, and which traditions and archives would allow the ghost of Jan Smuts, the greatest protagonist of the white race, to haunt the submissions of Palestine. Thanks very much.
Thank you so much, Christopher. I mean, you left us both starry-eyed and clear-eyed through this sort of the counterpunctual latter part. Fantastic, thank you. So with that, I'll sort of hand over to Vasuki to conclude the session, requesting her to sort of reflect on the theme with all three cases and maybe reflecting on, and this is her language, the imperfect yet necessary anti-racist politics of calling upon what are, in your language, your critical analysis, race-making juridical concepts in this moment before a judicial institution whose pronouncements more often than not have racialized and at best had racially uneven effects. So what does it mean for us to do that at this moment?
Great. Thanks so much, Adil, for convening us. And of course, I'm also very honored to be here with so many people I learn from all the time, including this afternoon. I'm going to draw and sort of work, as Adil suggested, on thinking about colonial genocide because some of those conversations have a very particular kind of resonance today, and I think central to those resonances is what the connections that Amy Césaire spoke of as a boomerang between genocidal violence by European powers in the colonial theater and genocide in Europe. And I sort of wind back to Césaire at the end, but just to say perhaps, and this follows from what Chris was saying as well, that the apex crime status of genocide in international law suggests that of all the kinds of atrocity that international law denounces, it claims to reserve its most staunch censure for racist atrocity. But that's where, perhaps it's precisely where international law may be having its greatest, perhaps one of many of its greatest gaps. And in that context, I just want to highlight sort of 5 sort of theses, and perhaps there's much more that can be said, but let me speak to about 5 dimensions of the reverberations of the boomerang that Césaire spoke about in terms of and how we talk about genocide today. So firstly, rather than approach genocide with the question, is it genocide or is it not, there is profit in foregrounding the multiple meanings of genocide and thinking with their both unsettled and unsettling tensions in sort of a whole range of different disciplines, law and ethics, colonial and racial, the immediate goals of amelioration and larger structural goals of social change. All of these are with us today. It's a story about victims and a story about perpetrators, a story about Europe and a story about the colony. Political economy, appropriation, dispossession, race making, and racial annihilation, that these are all different dimensions of genocide, and them rather than, and while there may be a focus on trying to narrow it down, name it, legalize it, have a juridical story that pins it down, there may be actually value in looking at what's at stake in these multiple meanings of genocide. Secondly, there's also value in a parallel unsettling with the historical reference of genocide, in this case, situating genocide of the middle of the 20th century in relation in particular to the settler colonial genocides that were part of the system of accumulation by dispossession that birthed the current world system. These multiple historical reference haunt, and we might say foreshadow, the genocide that we are living through today. Relatedly, building on the political economy work of Indigenous Studies scholarship on settler colonialism as structure, not event. In other words, we might want to challenge the notion of genocide that separates extermination from exploitation, or that disconnects destruction from dispossession, while holding on to sort of a TWAILR insight on foregrounding the global stakes, the question of world making and unmaking that is also embedded in all of these questions. If you look, for instance, historically at the genocides against the Herero and Nama in colonial Germany, the relationship between community and property was the terrain for deeply contested notions of race, what it was to be African, what it was to be German, and these contestations were partly forged through struggles over who had legitimate claims to land, and arguments for the appropriation of native land were intertwined with race-making arguments about civilization and productivity, as well as non-recognition of customary laws and the complex tenure systems of communal land ownership. In other words, race-making dynamics were forged and struggled over through the course of the colonial encounter, and property rights were often the terrain of battle, as they have been, of course, in Gaza, in Shah Jahan, in a whole range of different dimensions of the Nakba, and as it continues to unfold. Amongst other things, the story of genocide in Namibia requires attending to how the property law and racial taxonomies were co-produced so that lawfare redistributed land, but also, as in many other colonies, what Cheryl. And thirdly, that sort of takes me to this question about the core work of the Genocide Convention is often seen its repudiation of racial violence, that the convention's status as the apex crime is often read as both a repudiation of the Holocaust and a redemption of the moral authority of international law. How in some cases, looking at the racial drag on international laws and norms may require stepping back from the notion of race as if the category of race was always already clear. One dominant notion of genocide is framed through biology talk and culture talk in ways that elide political economy, and foregrounding political economy may help us better track the racially maldistributive architecture to the framing of a crime that is supposed to be the apex critique of racial atrocity. Rather, while historically genocide analysis has focused on racial hate aimed at victims, what happens when we flip the question and connect the dots between different projects of race making? In other words, how does one think about whiteness as a global process of imperial identity formation? And what does it open up, and what are the limits of that framing today as well? Fourthly, many claims for reparations for genocidal shocks and aftershocks of colonialism and slavery are negotiating a tension between the immediate goals of claimants seeking to ameliorate the ongoing injuries of this system, just as we are today when we call for ceasefire, as well as the broader goals of exposing the structural and ongoing weight of these afterlives that requires really a much larger scale transformation. One of them may also look to international law for a language with which to make their claims audible. But international law may itself be symptomatic of the world made by colonialism and slavery, and rather than a stable ground from which to critique that world order. My colleagues have already pointed to those tensions already, that these tensions and paradoxes haunt many legitimate claims, as even those that are unfolding in the International Court of Justice today for the recognition of historical genocides. And finally, and so this is the last point I wanted to make, from the beginning, there has been a tension between two potential lives of Genocide Convention. The first, the Genocide Convention as part of the post-war global governance regime, commemorating the memory of the Shoah by accruing humanitarian capital to the alternative life of the convention, is as a resource for anti-racist struggles the world over. Imperfect and not always fit for purpose, but nevertheless valuably translating local struggles into global conversations, and at the limit point, becoming a talismanic call to interrupt the routines of our world order. We're very much in that limit point today, because very early in its life, these two alternative visions of Genocide Convention came into conflict. The American Civil Rights Congress, for instance, submitted a report to the UN titled "We Charge Genocide" that documented American anti-Black racism by every branch of government and its accompanying genocidal history from lynching to police violence. This report was ignored by the UN and became yet another entry into an archive of lost, forgotten, and suppressed genocides. Clearly, holding the US accountable involved a greater challenge to the dominant world order than the machinery of anti-genocide lawyering permitted. So maybe just in conclusion, I just want to foreground sort of the vital, significance of convenings such as these. We have all probably been involved in a zillion conversations on these cases and on what's happening in Gaza today. But yet again, we come together, the significance of that coming together in the times that we are living in, where sort of despair in some ways is a constant companion. In some ways, the work of this gathering is not the sharing of expertise, but the forging of intellectual and political solidarity. And for that, Adil, I'm really appreciative. In that vein, what the solidarity is aimed at is to tell us to not look away as much as we might want to keep our eyes on Gaza, or as Cicéa's passage on the boomerang reminded us, what is most telling is not just how horrific violence boomerangs, but the long life of the horrors of indifference to its victims. He listed the long litany of violence in Vietnam, in Madagascar, and in a range of French colonies, while in Europe they accepted these facts. They read the headlines, they turned the page, they returned to their everyday lives. That acceptance and that indifference was a boomerang of a racist necropolitics. And after all, the genocide that we are all witness to today is not one that began in October. Rather, genocide had already been going on inch by inch, brick by brick, as settlements were expanding and bulldozers were fattening homes and olive groves.
We seem to have lost Vasuki there. I'll just wait for a second. Hopefully she can sign back in. I wanted to, we lose one, we welcome one. Welcome, Chad. I think Vasuki
Hi,
is...
Adil. Sorry, I don't know when I lost, but I lost at some point.
You were in the middle of this Cesare code. So the boomerang was on the way back.
Yeah. That's fine. That seems a good place to end.
No, but thank you so much. And for those really profound reflections, really. And I wanted to thank all four of you for a really rich set of contributions and for really setting us up. And really, I mean, instructive and illuminating. For the next section, I wanted to share with all of you a broad set of questions. Please feel free to address part of them or all of them, and in whichever order you choose. So, and sort of both questions in a way develop upon that last point Vasuki made. So first, in a way, both are questions about our stance and the kind of stance we might have as broadly third world international lawyers. One pertains to this moment and the return to, in a way, a lot of the institutions and the legal concepts we associate with the heyday of third worldism from the 50s to the sort of 70s. What do we do of this return, especially when it comes to our stance towards the state form in the Global South? Where, I mean, a modality that's other than the kind of revulsion of the state, the disgust for the state, or a embrace of the state. So any sort of reflections you guys have on that Vasuki calls it a skepticism towards the state, but what does that look like for you? The second broad question I have, and I want to set it out, pertains to what has been for me sort of a deafening and repressive silence of international legal academia with the question of Palestine, including amongst critical scholarship that has otherwise felt quite comfortable to address the problem of colonialism, race, and empire, which has been particularly striking given when contrasted with the responses from international institutions, especially humanitarian ones and actors and sort of experts within that. And wanting us to move beyond a denouncement of personal moral failures, of cognitive dissonance on the part of colleagues and friends, even university centers, and thus treating the question of Palestine as a limit experience. Could we perhaps offer a more symptomatic diagnosis of these failures that clarify their conditions of possibility? And again, what might be possible tactics in response from third world international lawyers that we can sort of, or international lawyers engage in solidarity and struggle in response to this situation where we find ourselves in sort of neoliberal universities? So I'll leave it at that.
So I can start maybe.
Yeah, please.
That's okay with everyone. So, so I think it's kind of interesting to see, speaking of third world kind of statism, which probably is true given kind of, you know, Nicaragua and South Africa, and I think Colombia might also now come to the ICJ and other countries. But but obviously, that's the point I want to get at. We still don't have Palestine before the International Court of Justice, right? So Palestine isn't there. It's absent, right? It's South Africa versus Israel. It's Nicaragua versus Germany. And interestingly, is also, which I think will become relevant, is the Gambia versus Myanmar. That case that also will be very relevant for what we're discussing right now. And I think it's actually good that Palestine is not there before the International Court of Justice, because obviously it would that would be a trap, right? What Nora Arakat calls the sovereignty trap, right? Because Palestine before the International Court of Justice would pretty much mean kind of a political arrangement with very kind of derivative sovereign features, but basically kind of a collaboration between the settler colonial imperial powers with the native, where you want to kind of reward good native behavior, rewarded with like very limited autonomy, perpetual subjugation, and definitely not self-determination, right? So it's good that in the sense of Palestine, you know, that we're not talking about kind of a state, though I know that, you know, there are people pushing for like now the kind of formal recognition of Palestine before the by kind of internationally before the UN. But maybe what I want to you know, draw our attention to that maybe it's not necessarily just a return to UN institutional architecture. It's this judicialization that I think is really, maybe I'm not saying new, because for instance, we know Nicaragua is not like a first, you know, it's not the first time that Nicaragua is going before the International Court of Justice, quite the opposite. We have like really relevant and important kind of case material coming out of Nicaragua. But there is like ambivalence with this judicialization, right? Because this run for courts, now the judicialization of the question of genocide, the judicialization of the of self-determination or the usurpation of self-determination, the legality or illegality of occupation, the question whether the crime of apartheid is being committed or not. So you can, and I think there are two ways to look at it. One, it's obviously because Security Council and the General Assembly have been unwilling or not capable of delivering any kind of justice to the question of Palestine in the 75 years so far. And pretty much, you know, and it's precisely because we've, and it explains exactly the kind of buildup of this genocide. You know, it's been building up over 75 years precisely because the UN architectural institutional architecture has failed Palestine, right? And so now that, you know, we can't, because it cannot be solved through kind of the other UN organs, it's not all up to the court, basically, right? So and at the same time, maybe the judicialization is also interesting to watch, precisely because of all these kind of live stream hearings, right? That have allowed millions of people all over the world not having to head to the New York headquarters, where most of us probably wouldn't have even been allowed to be granted visa to even be in New York or Geneva or Nairobi or wherever, you know, or even The Hague, right? But so you have a kind of democratization in the sense of, you know, much more people kind of being able to at least witness these hearings. But at the same time, I can see how some of my colleagues here, I mean, yeah, some of my colleagues basically, you know, with the question of genocide, for instance, being presented to the International Court of Justice, see themselves now being in the waiting room, you know, so hands off, right? Let's wait. Let's see what the International Court of Justice will say in maybe 2 to 3, 4, 5 years on genocide, you know? So it's almost as if the moment that it went to courts, at least some of the legal scholars, legal colleagues I have, definitely some of the nation states, you know, they feel like, you know, let's wait for the court to make its decision. So while the court might, I mean, in a way, that's the hope that it will come up with, you know, some interesting explanations vis-a-vis international law. We all have to, you know, we shouldn't put obviously too much hope in the court serving justice to Palestine, right? Because these are two different things, right? I mean, obviously, we probably will, the courts, the International Court of Justice in particular, will come up, or the ICERT committee will come up with like interesting kind of explanations vis-a-vis these legal concepts. That doesn't mean that justice will be served. And I think when it comes to scholarship we are watching, I think some of the disappointment, some of the disappointment comes basically because there are two problems here. One is that even like international legal scholars, even the critical ones, have in recent years and decades only engaged with decolonization and provincializing Eurocentric knowledge of international law. There was such a huge kind of focus on knowledge rather than like the epistemic kind of focus, rather than the potentially genocidal force that comes with it, right? So this focus on knowledge rather than the brute naked force seems to be one of the reasons that they haven't engaged enough with the actual power relations. And also because some of them possibly have realized or they're being made complicit through the very way our institutions, our universities benefit from exactly the powers, you know? So all the focus on the epistemological level and less focus on the actual powers, which means we become complicit, be it as part of the nation, the university as part of the nation state, or as part of supra-relational relations. And here I mean the European Union. And this power is real. And for some, it's so real that you can capitalize on these powers, right? These powers are lucrative powers. And we can see here that there is a vested interest, not only also from Israel, but from other countries to be, you know, to see Israel dominating in the region in particular, basically serving as the villa in the jungle. And I bring up this quote especially because not only Ehud Barak described Israel as the villa in the jungle, but also the European Union Foreign Policy Chief Joseph Borrell made a similar kind of quote that Europe is a garden, we've built a garden, the rest of the world, you know, is not exactly a garden. Most of the rest of the world is a jungle, and the jungle could invade the garden. And again, we find similar references also to Theodor Herzl, the founder of Zionism, where he proposed that the future Jewish state in Palestine would be, quote, a portion of a rampart of Europe against Asia, an outpost of civilization as opposed to barbarism. So again, you can see again almost the kind of boomerangs that Wizuka talked about, right? About, you know, the positioning of you know, whether it's Europe or Israel, you know, as a kind of you know, as there's this kind of particular kind of relationship between Israel and Europe here, obviously. And so basically, what I also want to say is that while many scholars see themselves basically as individuals, they have not kind of reflected enough their role as members of institutions, right? The role between the individual and the institution here. And I want to just basically end by referring also to the wonderful piece Sarah Dem has written on the very kind of complicity that universities can play, and at the same time their role in also, you know, enforcing international law, right? So I think the disappointment that you talked about, you know, has a lot to do with our very complicity as individuals in these institutions, right? And maybe for some, the lack or training, the lack of exercise in kind of a kind of a collective move, right? Which especially many universities are not kind of the faculty, they're not unionized, right? So to practice, to exercise kind of a collective move and to also see yourself as part or having a part in enforcing international law or being, you know, being also kind of liable to international law. I think that's why some of the international legal scholars have not shown kind of a commitment actually in practice to the very kind of subject matter they've been studying.
Thank you so much, Nahid. That was really helpful. And yeah, just that it's instructive to sort of take into account our institutional lives and take seriously our responsibilities in our institutional lives in that sense. And also putting the question of the state form as, in a way, the inevitable culmination of Palestine as well, that's really helpful to have on the table. Can I request Shahad, because you in person? Sorry, try now.
Yes. I thought I ran into one more problem. So aside from being held at the border, a tree fell on the tracks, and then my laptop crashed. So sometimes it feels like the world is just too aligned against, and my notes are gone as well, because by the looks of it, I managed to forget the notebook somewhere. So excuse me for that. I had much nicer notes in relation to the questions posed by you. I will do what I could with what I remember. So in relation to third worldism and state centricism, to be honest with you, third worldism by now looks like a very romantic ideal and aspiration. And if Marx's imagination that time goes around like a spiral, and we are at a point of repeating the political dimension where we go from a unipolar world into a multipolar world, where states of the global south could perhaps have a more of a breathing space. There is, of course, now that move towards asking, is this the time where we see a level of a revival of the 1960s, 70s moment? And it's indeed a very romanticized one that can have multiple pitfalls. The pitfall that you mentioned, in the sense of the past time, was very much premised on one, eradicating a good deal of pluralities, but at the same time nationalism, and then corruption as well. And now when we are trying to talk about a multipolar world, we're facing names of states and heads of states that inevitably are a part of the larger ailment. As Fanon would always tell us, with colonized peoples, you always have the elite as well, who are in your face in any attempt of liberation. So how is it that we've reached a space where it's proliferated? Actually, most peoples in the global south are not really represented by their states, and to find spaces of alliance there is quite very difficult. And this actually has come to the fore quite really clearly last week with relation to Iran, because, for example, in Jordan, that tension was huge. Everyone started to align themselves with Iran, and then other people would be like, but now we need the protection of the US and the likes. And I think what people are missing in that debate is the perspective of understanding that imperial powers will go about empowering each other. And then again, the perspectives given from global south movements in the 1960s and 70s remind us of the notion of non-alignment, along with other notions. And perhaps what I'm trying to say here is that indeed, looking back at a revival of the language used in the 1960s and 70s can provide us some spaces of wisdom. And here I'm not only referring to the ideal of non-alliance, but also the ideals of the concepts put forth by the new international economic order, the Declaration on Friendly Relations, the Declaration on Ending Colonization, which offer us a very structural perception of the world. Actually, they put forth an attempt to capture how domination works, and how domination works on an economic level and a structural, more embedded level. And perhaps from that point, I find some wisdom in reviving that language, or building on that language, in our attempt towards questioning the deeply embedded structures of domination in the world in which we live in. And another thing that I believe should then be focused on, aside from that revival, is the to that. And of course, now we have seen the rise of new actors on the fora, and these civil society actors. I don't know about the experience of others in international lawmaking. Mine has been very specific to corporate accountability. And there you always see in the back room these grassroots organizations trying to come in and make their own positions. And actually, that's where most of the third world ethos is felt. And they're trying to find patrons in the States. But perhaps now is the discussion, not only in relation to non-international organizations, but to the legal personality of peoples, and taking more seriously the normative value that comes not only from state practice but from people's practice, and a shift towards that. So on two levels, let's say, on one level, it is the recognition of the sound of the people as being a separate sound from the sound of the state, but also on another level, which is that the imperial struggle is very different than global South positions. And if we look at the case of Palestine specifically, what is happening in Palestine is that a tension is created and a grievance is created by an absolute lack of justice. And there the trajectory is quite clear. And that tension would then lead to geopolitical discourses that are erupting that could be used by any of the other actors. And clarity of perception in this context is really important, and which is why it's very important to separate ourselves from state alliances and kind of, if I may romantically say, call upon the ideals of justice as in the ethos of non-domination to help guide us in the compass of solidarity at this moment, as not to fall into the pitfalls that different state actors and different elite actors are seeking to place people in. And from that, I move into the second question in relation to the absolute absence that we've seen in the field. And of course, again, thank you for that, Adil. This has been one of the most prevalent other parallel themes that we've seen in the past 6 months. And it's not surprising, to say the least, because at the end of the day, we've always seen the double standards of critical takes on the law. And the fact is, most of critical discourses happen in abstract and are quite very shy to approach practice or reality at a lot of points. And when I was trying to contemplate your question, multiple things came up. One of which is, we live in a world where the question of morality is one that is shameful to ask, because due to the indeterminacy of questions of morality and justice in our field, we don't ask of these questions. But in reality, at the end of the day, one has to ask themselves, why are they in this field? And whether or not they recognize their own privilege and capacity to act within this field. For a lot of people, what I felt was an instrumentalization or a disassociation of this being just a job, and this being just a discipline in which we act, overlooking their own positionality. And not only that, partaking very steeply in what can only be called a form of methodological individualism. And that is in the sense of, and our discipline, of course, is premised on Western legal thought. It highlights individualism, loves individualism, feeds on individualism. But then what individualism means is that you will only assess life through your own lived reality, and kind of pushes us towards a reductivity in our conceptualization. So unless you have something to push you to imagine outside of your own direct lived reality, you really wouldn't. And this leads me to the idea that perceiving is very different than conceiving. And what a lot of people were able to see is they perceive of the case of Palestine, they understand what is happening, but to conceptualize what is actually happening, to understand the reality on the ground, and to expand one's perception and imagination to comprehend the reality of which we very abstractly go to legal blogs to speak of, is very much, takes a mental exercise. It takes a cognitive exercise that sadly it's too comfortable within institutional privilege that is laid out, and with also the cost of crossing that. The fact is, for some people, these are still morally mucky waters, and to take a decision at this moment could prove to be costly. And of course, most of us who've taken a direct position on this have had to pay the cost. Which is again why I roll back to the idea that it is a moral decision that was then taken. But then again, our discipline and its ideas do not exist in the void as a very niche positivist reading of the field would like us to have, and mainstream lawyers would like us to have. It's a world-making discipline, and when you partake in it, you are de facto also partaking in a professional exercise in relation to how is this world seen and how is this language seen. And there are multiple trajectories here. Some scholars opted for silence, which is in of itself very telling, but other scholars have opted into facilitating further what I described at the start, which is the mutilation, let's say, of course, a mutilated international legal body in of itself, but facilitating the weaponization of international humanitarian law. And how is it that we can approach this, Adil, is a very important and complex question that I've tried to handle at multiple points. At some points, it was just silence and stand and wave, because the gross level of violence of which the other person in front of you is speaking is simply not perceived in the conversation. And I grew tired of bringing forth that level of violence into the conversation over and over again. And indeed, this is not a new experience for any of us who've had a direct experience with war and who've had a direct experience with the subjects of which we speak as international lawyers and then came into the practice. That's indeed, and it's a very alienating experience where you feel like, where you feel as if the words that you speak of are completely devalued. So how do we respond to that, aside from the fact that truth will come out? And it's very sad that, let's say, from the position of where we stand, tragedy is only appealing when it's in the form of a spectacle that we can go to museums to speculate over or watch documentaries over, or when truth is very clear in our faces is only when we're able to engage with them and say, oh, look, this has happened in the past. And we are now, perhaps I could wrap this up by saying we're now actually at a struggle with temporality, because we are at a struggle with the present to showcase the truth in the present. And because we don't have time to wait for this to go ahead, we don't have time for more excess of representation and more excess of debate, because what needs to happen now is that we are up against, not just in the case of Palestine, the case of Palestine is showcasing a deeper normalization of violence against the other, who's not me or you, but rather people who are stuck under deep levels of a lack of privilege. And we're at a fight with time, because yeah, we can't still live in a time where people are still debating a game of chess above our heads of powers without really having the capacity to see reality as it stands. So sorry if I took too much time, but hopefully, in absence of notes, I made some sense.
Thank you so much, Ad. You made a lot more sense than most of us would with notes as well. So thank you. And just that it struck me that, you know, invocation of Marx and like the dangers of, first is tragedy, next is farce for third worldism, for third world international lawyers, and that sort of engagement with the farcical sometimes responses by international lawyers to these questions and these issues, and their comfort with museumizing them rather than sort of confronting and you know, the significance of courage and commitment to what we do. Chris, who I can feel is fading a bit, and Basaki, we're going over, so apologies especially to Naid and Christopher, but it'd be lovely to hear from both of you, Basaki and Chris.
Do you want to go over, Sugi? Should I go?
Go ahead. No, go ahead.
Okay. I don't know I was fading, but apparently I am. So I'll try to pick up. So that was wonderful, everyone, and Shad in particular. And I wanted to pick up on the idea that suddenly everyone became professional. Because what struck me about Ukraine was suddenly everyone became deeply invested in the facts and the reality on the ground. So I've been for my sins working in sort of international criminal law for upwards of 15 years now, thinking about genocides and all sorts of things. And at the time when I began, it was all about Sudan. I've never seen anyone say, look, this is actually an ongoing genocide, or can we find a Sudanese scholar or a Sudanese grad student or someone who's been to Sudan to sit on a panel with us. But in the first weeks of Ukraine, everyone was suddenly aware that the things we do have real life effects, and we need to make sure we don't West-splain. We need to make sure that we have to have a reckoning with our discipline and its reality on the ground. And that struck me. And now that, as you said, it's all gone. Now, all of a sudden, we've forgotten overnight that our discipline that our words have violence and our worlds have violence. And now we can very quickly disengage from that sudden effective turn, which I think we need to really problematize, not just the way that we can turn it on and off, but I guess in the situations that we can turn it on and off. On the question, and at the risk of being called a nationalist, I'm not going to be romantic about third worldism, but I do think it's something that certainly has struck me about my attempts to try to grapple with questions of the present is how often those questions have been answered already in the past. So I don't think we need to be romantic about third worldism, but if we look back to, for example, the New York Declaration about Convention on Crimes Against Humanity, or basically the Statute on Limitations, was adopted against the interests of Western states. It was hijacked by third world states, and in order to declare apartheid a crime against humanity, it was a mixture of civil society action, protests in the streets. It led to the adoption of the Apartheid Convention, where we can see the very structural accounts of violence that Vasuki and I are interested in thinking about. So the traditions are there. They are mired in difficulties and compromise and contingency, but we fail to learn them at our peril, right? So we need to reach back and see what's useful about those moments, and also to learn from those contingencies, and also to be aware of the tactics. So something that struck me about South Africa's approach is this idea that South Africa is the legal arm of Hamas. Right. Now, in South Africa, this makes sense because we know in the struggle against apartheid, we were told that the Apartheid Convention was a Soviet ploy, right? We can go back to Haiti. The Haitians were told that their freedom wasn't their own freedom. It was actually the French it was the British trying to destroy the French colony. So the idea that you can't imagine freedom outside a script that's imposed from outside, that any freedom, any project of freedom, any project of international law must belong to some other order. You must be an agent of the Soviets or Du Bois's. So when we charged genocide, Du Bois was an agent of the communists, right? Today, South Africa is an agent of Hamas. These tactics of the delegitimization of moments of third world solidarity are also the same across time. They shift as everything does, but I think we can learn a lot about sort of tactics and strategies if we look to those moments, but not starry-eyed, clear-eyed, but that we don't dismiss them because of what came after, that we can think about them in their concrete terms and engage with them for all their potentialities and all their pitfalls.
Thank you so much, Christopher. Vasuki?
Yeah, I don't have much except to sort of say that in a sense, the judicialization, the one I was talking to Michael Fakhri earlier today, and one of the things that he was remarking about was that, in contrast to sort of earlier moments, and we were thinking particularly of the Iraq War moment, where the powers that be, as it were, the Colin Powell's famous statement in front of the Security Council and so on, or the UN General Assembly, that even when they were knowingly and even on the face of it, where there were easy violations of international law, they struggle to somehow justify it in international law terms. And there's a huge focus on, this Security Council resolution and those Security Council resolution. That's quite different from the current moment. And perhaps that speaks to why what Nahed was speaking about earlier in terms of the judicialization of strategies in relation to Gaza, is that because of the ways in which international law, even its performance for all its is being abandoned in a particular way, that all the statements that, for instance, from the Israeli from the Israeli cabinet around human animals and all of that, it's just a complete push against international law as a terrain. And perhaps for that reason, there is a hope that international law could potentially have some interruptive potential, not to, as colleagues have said as well, not to romanticize international law as the path to justice. And certainly, as I've argued in relation to the South African submissions, perhaps the most important dimension of it was not the international law dimensions, but the performance of interrupting a dominant the dominant reception about what was happening in Gaza, what was on people's screens, and that performative work has an interruptive quality because of this particular moment, the specifics of this particular moment. So we are always now in this weird position, and perhaps all of our interventions in different ways perform that. We're both making the international law argument and we are deconstructing it ourselves, because people, it's not being either invoked or criticized with any earnestness in Tel Aviv or in Berlin or in New York or in DC. And so we are doing both. We are both trying to use international law to interrupt, in some sense, the way the interrupt the war, and we are using our own critical traditions to interrupt international law. So there is sort of this double move that I think is sort of unusual, certainly compared to the Iraq war moment. Of course, it was so yeah. I just that observation that I want to make. Yeah.
Thank you so much, Baski. That's a great note on which to draw things to a close. I did want to. There's one question in the chat, and I wanted to bring it up. It's asked by Ruby, who basically asks what the panel thinks about the possibility something similar to the Nuremberg Tribunal coming up in the case of Palestine in a time when, as per Ruby, international law is essentially held hostage by colonial powers. So in a way, just to sort of add to that, what do you think about where's the ICC in the coming months, days, years? I can see the reactions from, yeah. So maybe some reflection on that.
If I may, very quickly, so in a recent video by Anadolu Agency, they decided to cut a part of an interview that I said, and where they start with me saying international criminal law is dead. And so if in relation to, but international criminal court is dead in relation to, I think that's it. I think we should just give up on international criminal court. That's it. It's too many critiques for it was hanging by a line, and that line is gone. So the prosecutor office, everything about it, really. But as per an ad hoc tribunal, I don't know if you want to go further with the judicialization of Gaza and Palestine, but on my end, as a person who's working on corporations, I'm writing a letter to corporations telling them, be aware, beware that this is what we're looking to do. So of course, that's my way of saying we're thinking of scarecrows into the future. But if we are to think that what Israel is currently doing is crimes against international peace and security, historically speaking, ad hoc criminal tribunals did start. However, we're in a context of extreme case of exceptionality, but that's multi-layered on all senses. So none of us, so today I was speaking to some colleagues about the history of South Africa. I was like, how can we learn from tactics used in South Africa? And we were trying to trace about the difference in this case and how really we can't see that much forward. But whether or not it's happening, I don't know if it's going to happen within the premise of international law or not, but there will be calls for recognition, because without transitional justice, we would be unable to partake in repair. And from my perspective, there is no other negotiable the outcome for this. There is no other outcome that is acceptable for the Palestinian people but repair, reparations, and accountability. Other than that, they will never stop. So so if not the Nuremberg trials, even if international criminal law is dead, but another tribunal.
I'd just point out that the African court has a chamber, an international criminal chamber that has jurisdiction over companies. So perhaps we should, in our South-South movement, should be directing our attention towards institutions that have been thinking about this, and also has a range of crimes, not just the crimes of the ICC, but environmental crimes and other forms of crimes as well. So just punting my continent.
I include it in my scarecrow.
I think that's a good note to sort of end on. I guess I'll just say that, yeah, international lawyers, I was thinking about what is if the figure of the diplomat and the prophet is one, the two figures between which international lawyers just constantly oscillate, maybe the figure of the scarecrow is the figure of international law as interrupter, and the ethics of that might be something that we want to cultivate. But please join me and thank you to the audience who've also stuck around for this fantastic discussion. Join me in thanking our 4 fantastic speakers for making the time and sharing these reflections with us. Thank you, friends. It's been an honor to have you in this conversation. I hope to meet all of you in person sometime soon, but till then, I think this virtual medium has really made these kinds of events possible. This recording will be on TWAILR soon. So again, thank you to John and to Haris for helping out with this. Thank you.
Thank you so much, Adil.
Thank you.
Thank you, Adil. And thank you, everyone.
Suki, I had this image when you were talking of trying to ride a bike and fix it at the same time as a metaphor for what international lawyers are trying to do, trying to change a tire while you're